Buckle up for a wild ride in State of Texas versus Castillo and others. From a DWI suspect dodging cops in a parking lot to a shoplifting duo splitting up with stolen goods and a family assault case turning ugly, this courtroom's packed with chaos. Will these defendants dodge jail time, or will the judge slam the gavel? With high-stakes charges and a no-nonsense court...
Last name is Castillo. First name is Roberto.
Did we do it already? Okay, oh, and you ready?
I am.
Okay, Roberto Castillo, come up.
I've been in Montgomery County this morning, so I'm so late.
That's okay, you're not late. Good morning, Mr. Castillo. Sir, you stand charged with the offense of driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, Judge.
Okay.
So on January 1st, 2025, at approximately 4 a.m., the officer observed a vehicle traveling eastbound on FM 2920 in Harris County, Texas. The vehicle pulled into a parking lot and then exited the parking lot onto another roadway in an attempt to avoid the officer's patrol vehicle. The officer initiated a traffic stop on Tomball Parkway, and upon contact with the defendant, the driver and sole occupant of the vehicle, the officer observed glossy red eyes, slurred speech, odor of alcoholic beverage, and the defendant stated he had a six-pack of beer approximately 4 hours prior. Standard field sobriety tests were conducted, HGN 6 out of 6, walk and turn 6 out of 8, one leg stand 3 out of 4. The defendant was...
Here's something to chew on those field sobriety tests. 6/6, 6/8, and 3/4. That's basically a slam dunk for probable cause in a DWI case. But question for you, should a person's refusal to give blood automatically lead to a warrant? Let me know what you think down below.
Where the DIC and refused breath, a blood search warrant was signed and executed.
What was the stop for?
Allow me to read the DIMS, Your Honor, to see if he specified. So according to the officer, the vehicle pulled into a parking lot and then exited in an attempt to navigate away, and the vehicle crossed through the parking lot onto another roadway. And that appears to be all the officer put in the DIMS.
Tell me what he did wrong. What code, what transportation code has he violated? What ordinance, statute? Give me something. I mean, I can give you a little bit of time if you
Give us
want.
more time, Your Honor, so I can look at
Can you
this.
give me 5-10 minutes, Owen?
Sorry, Judge, I have other cases in Billings.
Okay.
I agree with the court. Even if they allege that he was attempting to, if he cut across, there is a violation for cutting across in order to avoid a traffic control device, but they didn't allege that. All they've got is him turning into a parking lot and back on.
Whoa, the judge is calling out the state's shaky case. Castillo's DWI stop hinges on a vague claim of evading by cutting through a parking lot, but the officer didn't cite a clear traffic violation. Legal breakdown. Texas Transportation Code 545.423 requires stopping when crossing property, and the officer claims Castillo didn't. But the defense argues there's no proof of intent to avoid a traffic device. Emotional stakes. The judge is skeptical, demanding video evidence. Is this a sloppy report or a legit stop? Should the judge toss the case if the video's unclear? Drop your thoughts in the comments as we dig deeper.
Onto another street, so that's not a law violation.
It's like 10 minutes and we can...
Yep, go to it.
Thank you.
All right. Just take a seat, don't leave. And then when you come back, we'll finish.
I'm back on Mr. Castillo, AC here.
All right.
Yes, Judge. So in regard to the crossing the parking lot, it was the officer's understanding, I spoke with the officer, that crossing the parking lot is a violation because he crossed right through, and the traffic code that we found is transportation code. Hold on.
Did you take a look at this?
Judge, I'm very familiar with the statute they're quoting.
Okay, what is it?
It's section 545.423. and it's crossing property, and it states that an operator may not cross a sidewalk or drive through a driveway, parking lot, or business or residential entrance without stopping the vehicle. And the officer said that he crossed, according to the DIMS, he crossed straight through onto the public roadway. And speaking with the officer, he repeated that as well, saying that he was at a slow roll and he just went straight through upon noticing the officer. And that's whenever he performed the traffic stop, as he crossed that parking lot.
An operator may not cross a sidewalk or drive through a driveway, parking lot, or business or residential entrance without stopping the vehicle.
Yes, Judge. And as the...
He never stopped at all.
Correct. And as the DIMS states, the vehicle pulled into the parking lot and exited the parking lot in an attempt to navigate away from the patrol vehicle. So he has entered and exited. He didn't stop.
First, Judge, that statute requires that you're doing it for the purpose of avoiding a traffic control device. There's an additional element.
Really?
Yes, Judge, if you look at the statute.
Hold on. See, there's only, it says, so that, what I read was A. B says an operator may not cross or drive in or on a sidewalk, driveway, parking lot, residence, or residential entrance at an intersection to turn right or left from one highway to another highway.
In order to avoid the traffic control device.
Correct, but that looks like it's an or, not and. Or, you know, unless you show me unless you can show me differently. I mean,
It is an or, Judge. I agree with that. However, may I address another issue?
of course.
If you listen to the DIM summary, he says he intended to stop my client to begin with. Then my client, in order to evade him, rolled across the parking lot. There's no explanation as to why he started attempting to stop my client in the first place. I recognize, of course, that police have many and multifarious functions, but activating emergency lights and attempting to stop somebody for some unexplained reason.
I didn't hear that.
Well, Your Honor, the DIMS reads...
It's certainly interesting.
It reads different because it says while the officer was patrolling, he observed the vehicle, and it immediately goes into how the vehicle pulled into the parking lot and exited in an attempt to navigate away from the officer's patrol vehicle. And after that point, it says the officer initiated his patrol lights. So he wasn't attempting to stop him at the point that he entered the parking lot. All the officer articulated was that he was attempting to navigate away from his vehicle.
I mean, what it sounds like to me is he sees the officer and just tries to get away, and then the officer sees him do something that's maybe a violation of the transportation code and pulls him over right there. Had he kept driving and just gone straight, perhaps it would have never been pulled over. But the virtue of the fact that you go and do that, you know, if there wasn't a violation, I would kick it all day. But I mean, they, you know.
May I address one other very shortly?
Please.
The way he says in his DIM summary, he says, the purpose for crossing is to evade me. He is thinking this man is trying to evade me. And that certainly implies that he was trying to stop the defendant before the defendant started and turned into the parking lot. Otherwise, why would he say he was trying to evade me? In other words, if he's consciously thinking this man is evading me, he's doing something that would lead the defendant to evade.
I agree with you.
So without showing as why.
Okay, hold up, did you catch that? The judge just found probable cause but still left the door open to review it again if the video tells a different story. That's rare and smart. Also, what do you think? Was the officer's suspicion based on real evasion or just a hunch?
I agree with you, but the fact remains is he went through, and it looks like he may have indeed violated that part of the transportation code. Now, pull the video. If the video shows you something differently, come back and we can do PC again. You know, I'm always happy to revisit it, but perhaps if he would have kept going and not done anything, not done that, he wouldn't have gotten pulled over. If he would have, and nothing had done, there had been no errors, then you know what would happen.
Understood.
I'm going to find probable cause for now. What was the last name again?
Castillo.
Okay, Mr. Castillo, I'm going to find probable cause. And let me tell you, you speak English, right?
Yes, sir.
And by no means does this mean that you're guilty of this offense. This just means that there's enough to go forward now. That's all it means. You got a great lawyer. He will handle the case for you. If there are always any issues, you guys can come back and reapproach and we can go from there. I am ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming alcohol or illegal drugs, I'm going to revoke your bond. As long as you have a valid Texas driver license and liability insurance, you may continue to drive.
It's eligible, Your Honor.
Great. You have a lawyer. Because you have a lawyer, I will waive your appearance. You don't have to waste your time coming to court, but just stay in contact with Owen. He will tell you when you have to come back to court. If Owen tells me he can't get a hold of you because you're playing games, I will issue a warrant for your arrest. Do you understand?
Yes, sir.
Okay. For For now, I'm going to have you sign your release at Victoria. We'll have you get with Maddie for your bond conditions, and then you guys are free to go. Thanks. Of course.
Right this way.
Wow, he just picked up an Agasol. You saw that, huh?
Christopher Duran?
We had a lot of issues with him, Lori. Many issues. No, you can be on probation.
Go straight through.
All right, bring it.
All right, page 19, Lopez, come on up.
Good morning, Mr. Lopez. Sir, you were charged with theft. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On December 31st, 2024, an officer was dispatched to HEB in Harris County, Texas, regarding a shoplift that had just occurred. The officer made contact with the complainant. The complainant is the manager of the HEB and observed the defendant Diaz and defendant Lopez walk through selecting merchandise and place items inside of a red HEB bag and communicate with one another and place items inside backpacks they came inside the store with and roll up the red HEB bag and place it on the bottom rack of the cart. Defendant Lopez paid for 3 items left in the cart. Defendant Diaz went inside the bathroom and reemerged after defendant Lopez paid for the items. Neither defendant attempted to pay for the items in the backpacks or the red HEB bag. The complainant locked the produce exit doors and attempted to confront the defendants. The defendants split up with respective backpacks. Defendant Lopez carried the red HEB bag and the defendants ran from the store management and security in opposite directions. Defendant Lopez was identified by his name and date of birth.
Okay. Mr. Lopez, I'm going to find that there's probable cause to go forward with the case. The co-defendant is...
Talk about a heist gone wrong. Lopez and his co-defendant Diaz tried to pull a fast one at Heb, stashing goods in backpacks and a bag, only to bolt when confronted. Legal note. Texas theft under $2,500 is a Class A misdemeanor, carrying up to 6 months in jail and a $2,000 fine. The judge slapped strict bond conditions. No Heb, no co-defendant contact, no drugs. Emotional stakes. Lopez is jobless, facing court costs and an appointed lawyer. Is this a one-time slip or a pattern? Should the judge go harder on coordinated theft? Let us know in the comments as we shift to a heated family assault case.
Co-defendant in our court?
We had him last week.
He's in here? Okay. I'm ordering you as a condition of your bond not to go to any HEB. Do you understand? If I find that you go to any HEB, if I find that you pick up a new case, if I find you have contact with the co-defendant, I'm going to revoke the bond, put you in jail. No more PR bonds. Do you understand?
Sure.
What do you do for a living, sir?
I'm currently looking for a job. Yeah.
I'll have you fill out an application for an appointed lawyer. I am ordering you as a condition of your bond not to consume alcohol or illegal drugs as well. if I find that you're using, it's not going to go well. Do you understand?
Your Honor.
Judge, you have an important call.
Are you still in trial? Say it again. Oh, Sarah. Yeah. You done?
Yeah.
How was it?
I did.
Wow, congrats. What did you try?
DUI.
Nice. Yeah, he was telling me, we're all big fans. Good job. Yeah. Mr. Stoll, I was waiting for you. How are you, man? You ready?
Yeah, we're ready. My internet's not really working to this, but.
What do you need?
We're just gonna do pre-PC and bond conditions real quick.
Okay.
And get, Mr. Duran out of here.
Good morning, Mr. Duran. Mr. Duran, you're charged with racing on a highway. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Okay.
Officers were working in undercover capacity, and they advised, they
Now we're shifting gears racing charges. But check this out. The officer defines rolling drag race, but never clearly says he saw both cars race side by side. That's a major gap. Do you think that definition alone proves intent? Type yes if it's enough, and no if it's missing facts.
observed a black Jeep engage in a rolling drag race with a yellow Corvette, unknown license plate. Rolling drag races when two or more vehicles align their vehicles from their moving position while traveling side by side on the public roadway. The vehicles then simultaneously accelerate forward at a high rate of speed, attempting to outdistance and outgain each other in a competition of speed. The black Jeep and the yellow Corvette were heading west on the highway at 40 miles per hour. And
A Jeep versus a Corvette?
Right.
He was in the Jeep,
Really?
Your Honor. He was in the Jeep.
And accelerated at a high rate of speed of 90 in a 65 miles per hour zone.
Hare versus a tortoise.
They maintained visual on the vehicle, observing it exit the highway and enter in the parking lot of a Buc-ee's. They approached the driver of the Jeep. The defendant here stated he knew why he was in the parking lot and he was just trying to have fun.
Your Honor, in the DIMS report, the officer does give the definition of what a roll race, what a drag race is. However, just after that, when he closes the the caption of where the definition is, he never says that he ever witnessed my client and the Corvette line up side by side and accelerate from a point side by side in order to outdistance the other vehicle.
Didn't you say that they like kind of slowed to some kind of like next to each other and then they flew out? I thought I heard that.
Yes, because as the DIMS is written, the officer says he observed the black Jeep, the defendant's vehicle, engaged in a rolling drag race. Then he goes on to define what he meant by that. And that's when he says they slowed and they went side by side and they accelerated.
I think it's a poorly written DIMS, in my opinion. I think it would have been better had he
Well,
said.
but I guess he's trying to explain to us, hey, what this is, because not many people may know, but I saw them engage in this.
Yes, sir.
Right.
And this just happened 3 days ago, so we're going to wait for the offense
We are still
report.
waiting for the full offense.
And nevertheless,
Right.
that's what happened is they kind of slow down and then they take off, right?
Yes, sir.
Yes, Judge.
Okay. Do we have the co-defendant? No?
There was, he was the only one.
All right. Mr. Duran, I'm going to find that there's probable cause to go forward with the case. Have you guys run his license to see if he has a valid Texas driver license?
Oh, right.
Your Honor.
Okay. No more. 610 is not the place to do this, and I'm making that a condition of your bond. There are proper places in Houston, but not on our freeways. Do you understand?
Yes, sir.
I'm making that a condition of your bond. If I find that you're doing it again, first thing I'm going to do is I'm going to put you in jail. And the next thing I'm going to take your ability to drive away. Living in this city without the ability to drive sucks. All right, come on, no more. You understand? You've got a great lawyer. Listen to Mr. Stoll. He'll take care of you. I will waive your appearance. You don't have to waste your time coming to court, but you must stay in touch with Mr. Stoll, and he'll tell you when you have to come back to court. If he tells me he can't get a hold of you, you pick up a new case, I'm going to end up revoking your bond. All right, guys, please. So he can't leave until he signs conditions, and then he can go. Can you file?
Still no reckless, no racing, those type of conditions,
Et cetera. Yeah.
Raven Andrew?
Because these are for the state, correct?
State, yeah. Is it Tyren? No.
Yes.
Please. Mr. Collins, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We're going to do a probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On December 31st, 2024, at 2:35 p.m., an officer was dispatched to 12600 Dunlap Street, Houston, Harris County, Texas, in reference to a disturbance unknown weapon call. Upon arrival, the officer made contact with the complainant, who stated the defendant is her son and that he assaulted her. The complainant stated she lives in an apartment with her two sons. The complainant stated that a month ago she asked the defendant, her eldest son, to help pay for rent, and the defendant agreed to pay a certain amount. The complainant stated she got tired of asking and told them that she was not renewing her lease. The complainant told the defendant he needed to move out by December 31st. On that day, she arrived at the apartment to turn her keys in and do a walkthrough with the complex manager, the witness. The complainant stated as she was removing the locks from the doors, the defendant pushed her with both hands and punched her in the chest with a fist, causing pain. The witness stated the defendant was acting aggressive and was refusing to leave the apartment. The witness observed the defendant push and punch the complainant.
Any dope or alcohol?
No allegations of drugs or alcohol, Judge.
Do we know what she wants?
Yes, Judge. I spoke to her yesterday and she is requesting no threatening or harassing contact and that he not be able to go near her new residence.
Got it. Okay, Mr. Collins, I'm going to find that there's probable cause to go forward with your case. I'm ordering you as a condition of your, well, hold on a second, let me see. It looks like a protective order was issued on the 1st of this month. I would get to know it, because if you violate this protective order, the state can and probably will file a violation of protective order. It's one of the worst cases you can pick up. You violate conditions on a VPO, I can have a hearing to hold you at no bond, zero bond, and I will do it in a heartbeat to protect my community. Do you understand?
Yes, I also had a witness too.
Stop. You will get the opportunity to fight. Now's not the time. I got a bunch of DAs here. I don't want you to say something. You'll get the opportunity, just now's not the time. I am ordering you as a condition of your bond not to have any threatening or harassing contact with the complaining witness in this case. Understand what is threatening or harassing doesn't matter what you think. I could care less. It's what she perceives. So if I go like this, is that threatening, harassing? It most certainly is, and it can be a basis to revoke your bond. Do you understand?
Yeah.
All right. Tell me, what do you do for a living, Mr. Collins?
I work.
Do you have enough money in that work to hire a lawyer?
No.
Tell me about what you do then.
I work as an HVAC tech.
All right, so what I can do is I can give you an application. I need you to fill it out. Don't just put zeros, because I'm going to send it right back to you. I need you to fill it out. Be honest. I'll take a look, and if you qualify, then I'll give you a lawyer. I am going to file conditions that you're not having threatening or harassing contact with mom. It's mom?
Mom and Judge, the protective order says no going within 200 feet of her previous residence. She gave me her new address. So if we could
do you want to
add
refile it?
We could. Do you know how to
Put the correct address in the moment? You want them all right, I'll print it out and we'll just amend it. I need to know, or I'll give it to you. You put the correct address.
Yes, Judge.
So, Mr. Collins, you're not allowed to go where she lives. Do you understand? If you go there, I'm going to revoke your bond. I'm going to put you in jail. You need to understand, if you don't have anyone that's going to pony up $5,000, $10,000 to get you out of jail, you'll be stuck like Chuck in there until this thing is over with. Consider that when you're out there in the free world. I'm not asking for much. Just don't become a danger to our public. Don't violate conditions. That's it. All right. Stephen, do you mind giving an application? Do you mind filing no threatening, harassing contact and no weapons?
Approved already, so
Okay, so all they need is the application?
they need the application.
Okay, it's old, so what we'll do, we'll give you just a couple weeks. Got to be here at the next setting, everything done. We'll send them for a TRS at the next setting, and then we'll go from there. Huh? Yeah, okay. Yes, ma'am. Thanks.
Good morning, Your Honor. Happy New Year.
What's up, man? Happy New Year. I wanted to wait for you, so we didn't.
I appreciate that. Yeah, I have Mr. Coleman, he will waive PC on it. So, all good?
Any priors?
No, he did that first.
Okay, so just same as usual, just no drugs, no alcohol, no license, no driving, and all that jazz. Done.
All right, thank you very much. Good to see you.
You too. Yes, sir.
Very Spitz, are you ready, Judge?
Say it again. Okay, I'm ready when you are. Is this a true first?
Sometimes move it down to a first.
Right, but it's not a second though.
Oh, that's fun.
It's not a second.
It is.
It's a second, but it's being pled down.
Right, it was charged as a second to a first.
All right. Good morning, Ms. Smith. Ma'am, you were charged with driving while intoxicated. Second offense, you were facing up to a year in jail and or a $4,000 fine. Looks like you guys have worked the deal of a century because they're going to reduce it to a first, which I don't know if you realize this, but this bypasses the mandatory 5 minimum in jail that you would normally be doing. So understand that this is a big one, but you still have to understand 1 and 1 are 2, 2 and 1 make 3. What happens on the next one? You were looking at a felony charge, a minimum of 2 years in prison, a maximum of 10 years in prison. All officers will presumably do, look at your record. If you get pulled over, they smell alcohol, boom, right back in. If I were you, even if you had a sip of alcohol, I would never get into a car because you were taking a humongous risk. Do you understand, man?
Yes, sir.
It is a very, very serious business. The agreement that you worked out is they're offering you 180 days in jail to be probated for 15 months. For you to complete this probation successfully, you must do a repeat offender DWI education class. You must do 2 victim impact panels. You must also do a TRAS, which is an evaluation to see what other conditions you may need. If they assess further conditions, you must fulfill those. If you don't, then into jail you go. If you consume alcohol while you're on this probation, if you pick up a new case, if you drive when you're not supposed to, your bond, we're going to issue a warrant for your arrest, put you in jail. I'm going to bring you back out here. We're going to have a hearing to see whether you violated the probation, and you're looking at 180 days in jail. Do you understand? You are giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You could be deported, excluded from the country, denied naturalization. Under federal law, you give up the right to appeal. Once you plead guilty, there's no turning back. It will go on your record. It's going to stay there for the rest of your life. Is this what you want to do, man? How do you plead to the offense? Guilty or not guilty? I'm going to find you guilty. You must also have complete substance abuse treatment, no drugs, no alcohol. You must maintain a guardian interlock and no breath test refusal, meaning that if you're pulled over in a car and an officer asks you to submit to a breath test, you must do it. If you don't, you're in violation of the probation. Alex, can you see if she has a license, please?
Yes, Judge. It's eligible, Your Honor.
Okay. Okay, you can reduce your fees to the minimum, and we'll waive the court costs and all that. Okay. If you ever have any problems, come back and talk to us. But the worst possible thing that you can do is just take off, because that it assures a warrant will be issued. The other thing is, don't use alcohol. Do you understand? Okay, ma'am. How do you put, she said guilty, right?
What a whirlwind in state of Texas versus Castillo and others. Castillo's DWI moves forward with probable cause, but the judge wants video proof hinting at a possible revisit. Lopez faces theft charges with strict bond conditions. No HEB, no co-defendant contact. Collins gets a protective order for assaulting his mom with a zero-tolerance warning. Ms. Smith scores a plea deal, reducing her DWI second to a first, with 180 days probated and a guardian interlock. Legal takeaway: Texas cracks down on DWIs up to 1 year, $4,000 fine for second offense and family violence. Is the judge's tough stance enough to deter repeat offenders, or should rehab take priority? If this shocked you, hit that like button, share your thoughts in the comments, and subscribe for more jaw-dropping courtroom breakdowns.
Okay, all right, good luck, man. We'll have you see probation officer. All right, thanks. No, she needs a guardian interlock before she starts driving. Does she have a portable? Or what does she? Okay, you cannot drive.
I have both devices.
You do, you have one in your car as well? Okay. You must maintain that one in the car. I will take the portable device off now. You got to understand those that, bless you, I can't pay for the device anymore though. Once you get on probation, I've been paying for you, for both devices now for you, but once you get on probation, I can't pay for it anymore. You're going to have to pay for that yourself, but I have waived a ton of fees. I mean, I've waived around $5,000 in fees for you now that you would otherwise be responsible for. So just be careful, don't use, and if you ever have any issues, talk to Josh, me, and we can help you out.
As far as the interlock device, I will learn from them how much it's going to cost, or how does that?
As far as the logistics are concerned, I don't know. Yeah, I don't know. I mean,
it's already on there, so I guess I would keep the one that's
yeah, if you don't pay, it's going to go into lockout, and if it goes into lockout, a warrant issue. So just make sure that you get everything done well, so you know when to start paying for it. Okay. Okay, guys. All right. Thank you, man. Good luck. Okay. 30. I think what's the minimum is what, 25 or is it 30? Okay, then do the minimum of the 25. Yeah.
I just had a question about Francisco Garcia on document.
Is it on docket today?
Yes, Your Honor.
In custody or on bond?
In custody.
Yes, sir. Page 35, Your Honor.
Thank you.
I saw that it was set for bail review, and we had submitted a waiver yesterday of the bail hearing in Court 8, but I didn't know if we needed to.
Let me see. I can do it for you. Let's see. How did it get transferred at such a late? I mean, it's 125 days old. It's weird, right?
I think the alleged jail fight is the assault. And so I don't know, maybe there were co-defendants in 8, but maybe there's some issues there. If they're trying to separate them, maybe.
Oh, is this with Cordova? Got it. Okay. Okay. Yeah. Just so the felony set for the 10th. Do you want to do it a couple days after, or do you want it longer?
A couple days after.
Okay. Yeah. Whatever he wants. Yeah. Okay. Thanks.